confusion I find with people understanding what Social Security disability is and what SSI is. I hear people will call me frequently. I have an SSI claim, or I've been denied for SSI. And then when I talk to them, I find, in fact, it's not SSI at all, but it is Social Security disability. So I try to help people understand the difference between the two programs, because they are vastly different, although they're administered similarly. First of all, remember, Social Security has an acronym for everything. And throughout the evening, I will give you acronym alerts, so you can learn these acronyms. For example, on the screen, we see SSDI, Social Security Disability Income. We also see SSI in number B, and that is Supplemental Security Income. Now, Social Security disability is regular Social Security disability benefits for a person who have worked at least 10 years during their lifetime before perhaps they were injured, and 5 years of the last 10 years before they became disabled. So that means that if a person is injured, let's say in 2010, just pick a nice round number, they must have had 10 years of work throughout their lifetime total. You hear the 40 quarters talked about a lot with Social Security. Well, I take the lazy way out and call it 10 years, but it really is 40 years, 40 quarters of paying in Social Security, FICA taxes out of your paycheck, or if you're self-employed on a Schedule SE, that is part of your 1040 individual tax return. And so you must have paid in taxes at a certain level for 40 quarters. Again, I'm lazy, I say 10 years, because it amounts to 10 years. 40 quarters is 10 years. The difference is, it doesn't have to be 10 years in a row. It can be 1 year back when you were 18, 5 years in your 30s, 5 years in your 40s, and then you're stay-at-home momming for the rest of your life or something, okay? So you've got your 10 years in. So what that means is that for Medicare purposes at age 65 and for retirement benefits starting at early retirement, 62 or later, you would be insured, fully insured, and that's the term that Social Security uses. Insured, because when I use that term with clients or folks that come in the office, they believe that I'm talking about their medical insurance or their long-term disability insurance plan through MetLife. No, Social Security uses that term, insured. Now, to be insured for disability, however, it's a little bit different. You not only have to have your 40 quarters, your 10 years in, but you also must have worked 5 of the 10 years before you became disabled. In other words, 20 of those quarters must be in the last 10 years before your injury or illness or disability, disabling disease or whatever's going on, okay? So, for example, I had a lady in the office today, and we were calculating her date last insured. Let me give you an acronym alert. Social Security calls that DLI, date last insured for disability purposes. Now, her date last insured is December 31st, 2015. She had worked through the end of 2010 before she became too sick to work. So, in effect, she had worked real steady up to that point. So her date last insured ran another 5 years beyond when she stopped working, which would be December of 15. Now, what that date means, or what the significance of that date is this. If a person becomes disabled, they must be severe enough under Social Security rules to be found disabled on a date prior to that date last insured expiring. So if I had an individual whose date last insured was March 31 of 2004, if they're in a coma today, it doesn't make any difference. They're not going to get a nickel. We had to have proved severity by March 31st, 2004 in my example. Okay, so everybody with me on this date last insured, DLI. Okay? By the way, you do know what Social Security's favorite acronym is. NO. Anyway, just kidding if someone's here from Social Security. Item 2, a Social Security disability recipient does receive benefits after receiving Social Security disability, gets Medicare after 2 years on benefits. So, for example, if a person is injured on January the 1st, 2013, and they meet the medical rules that Social Security has for disability, Social Security does not pay the first 5 months. So February, March, April, May, June, July of 2013 would be your first disability check from Social Security. Then 2 years from that date, you would get Medicare automatically without applying for it. Because I have people come in the office and say, look, Mel, I don't care about the money. You know, we've got enough. My husband works, whatever. Boy, I need Medicare because it's cleaning us out, the medical expenses. And so even with being found disabled, you've got to be found disabled and on benefits for 2 years. And really, if you think about it, 30 months, 29, 30 months, because of the 5-month waiting period from the time that you left work. So that's a little tough on people sometimes that are on regular Social Security disability, because those folks can be as rich as Bill Gates and still get Social Security disability because they've paid in the FICA taxes those years. They have insured status. Their they were injured prior to their date last insured expiring. So Social Security does not count any pensions, rental income, in other words, any unearned income at all. The only thing Social Security looks at is earned income, because if you're claiming disability and you're working, that's something they're going to look into. And you may be able to work, and we're going to talk a little bit about that. And they are interested in public benefits. There is a brochure. If you'd like one, you can call my office, but that is how workers' compensation and state disability affect your Social Security disability benefits. And depending on how much you made in the last 5 years before you became disabled, they may or may not affect your benefits. In other words, you may be able to collect the state and the Social Security payments at the same time. And of course, state disability only runs 1 year. That's a maximum of 1 year. Whereas state Social Security runs all the way to full retirement age. So if full retirement age for you is 66, then at 66, they would take you off of the disability program, put you on Social Security retirement, and you get to keep the higher of the two payments. So it's a good deal, particularly if somebody's a little bit older. They don't have to take that early Social Security retirement, because at 62, if they take early retirement, they take a 25% reduction in their retirement check from Social Security and cannot increase that, other than working some and getting the little cost of living increases and credit for the taxes that you're currently paid in. Okay? Paying in. Okay, everybody with me now on the state last insured thing and Social Security disability. It's a benefit that you paid for, you paid taxes for. It is not welfare. And conversely, if you're not insured, you're not going to get it because you didn't pay enough taxes in, or at least in recent years. Okay? Let's move on to Supplemental Security Income, SSI. Now, SSI is not part of the Social Security system. It is the money that funds SSI is federal Medicaid. It is out of the General Treasury of the United States. It is welfare. It's for people who have not worked enough to be insured for regular Social Security disability. So SSI, Supplemental Security Income, there are two ways to get it. Number one is being disabled and meeting the medical rules that Social Security has for regular SSDI as well as SSI. They are exactly the same. as far as meeting their disability rules. However, with SSI, because it is needs-based, you got to be flat out broke. Flat out broke. It's the same rules as Medi-Cal, because that is also federal Medicaid. It's the same rules. That's why I brought this brochure tonight. If any of you are on SSI, what you need to know, because you have a duty, an absolute affirmative duty to report any changes to the Social Security Administration. I mean, almost every day it seems like I get a call from somebody who ends up with a big overpayment because they did a little bit of work and they forgot to pay Social Security, or they didn't think it was would hurt their benefits and that kind of thing. See, with Social Security disability, regular disability benefits, you can work, and there are certain programs, they even have a ticket to work program where they will pay for rehabilitation, all kinds of stuff, okay? However, SSI is different. SSI, because it is needs-based welfare, they will let you key. If you get a job, let's say you get a job making $200 a month and you getting the $854 a month in in SSI. Well, they don't take away the full 200. What they do is they let you keep the first $65 that you earn. Then they start reducing it $1 for every $2. So there's not a lot of incentive if you're on SSI to work, because they start taking it away. Now, there may not be a big incentive with regular Social Security. That's based on what you earned 5 years prior to becoming disabled. But I'm suggesting this to you before you get a job. Some of you may very well be receiving Social Security and working currently, and so you probably know the rules here and the drill. I don't probably have to tell you much. But the fact of the matter is, if you have not and you are contemplating maybe a part-time job or something like that, then you make sure that you check in with Social Security. And let me just take this a step further. Whenever you get word from someone at Social Security, that the rule is this or the rule is that, go on their website, www.ssa.gov, and just in the search box, put SSI disability, and you'll come up with all their brochures, this one included, or Social Security disability. And you'll find they've got so much information, frankly, on that website that if anyone here has brain injury, it will put you in overload and hurry. But the fact of the matter is, there are tons of information on their website. So the point being is that before you go out and take any step, or you take anyone's word for what we're saying at Social Security, you make sure you do a little bit of research yourself, or get somebody, in the family or something to help you a little bit with it. And make sure you understand the rules, because I had serious brain injury, called me here on back, a fellow that off and on I've gotten calls for the last 10 years on him, and he has another $65,000 overpayment. Only now he's at retirement age, and he doesn't have the ability to work and pay it off. So you just be real careful with that. I mean, I'm not discouraging anyone from trying to work by any means, and many of you probably do work even with your situation. But the fact is, just be a little careful. Now, let me just briefly explain how Social Security disability, now not SSI, not the welfare Medicaid thing, but regular Social Security disability works if you want to try to go to work. You may already know this, but Social Security gives a person a 9-month trial work period. Now, that 9 months, however, is not necessarily 9 months in a row. It is spread out over a rolling 5-year period. So you work 2 years or 2 months in 2010, 5 months in 2011, and 4 months in 2012. You have burned up your trial work period. Now, a trial work period is $720 per month gross. So if a person is making $720 or more, that triggers a trial work period. Now, during that trial work period, they can make $1 million a month and still keep their Social Security benefits. This is to help a person get established on the job and be able to try to return to work. However, any month after the 9 months expires, that you make substantial gainful activity. And SGA, acronym alert, SGA. That's what Social Security calls it, is substantial gainful activity. This year, that amount is $1,040 per month gross. And if you make $1,040 a month gross, you are not disabled under Social Security rules. So, they give you your 9 months. You can make all the money you want. Then, any month beyond that you make $1,040 gross, you will lose your benefits for that month.
That 9 months.
Yeah, it's 720. Yeah, I don't think it went up this year. I can't remember at the moment, but it's very close to that. Let's put it that way. I think it's still 720. That's not 1,040. The 720 is a trial work period. Now, I'll warn you about another thing. A trial work period sometimes will trigger a continuing disability review, where Social Security tries to determine that there has been medical improvement and boot you off. And making $1,040 a month. But anyone who is making $1,040 a month is not disabled under Social Security rules, as you'll see when we get to how Social Security determines one is disabled. Okay? Oops, wrong one, Robert. I'm sorry, I hit the wrong button. Let's do that. Okay, how is physical or psychological disability determined? Well, let's talk about the definition that Social Security uses, because it's pretty irrational. Most of us, for example, if someone, well, let's do it this way. If someone came into my office and said, Mel, I have terminal stage 4 cancer. We'll win, right? Maybe. It's not the label with Social Security. They don't care if you call it traumatic brain injury, or you have cancer of the brain, or you have a twisted left foot. They do not go by the label. So let me define this for you so you're clear on it. Social Security, first of all, has a definition. And that definition is that the disability must be expected to last at least 12 months or result in death. So if someone is terminal, and they're expected to live 9 months, then Social Security would go ahead and take an application on them. But again, let me remind you, Social Security does not pay the first 5 months. So in that example, if the poor person did pass away in the 9th month, they would only get, or the family would only get 4 months of payments, okay, because they don't pay the first 5 months no matter how sick you are. So it has to be expected to last at least 12 months or result in death. And you must have a medically determinable impairment. In other words, one cannot allege all of this back pain and have no x-rays, MRIs, CAT scans, whatever, to back it up. So whatever you allege as far as subjective limitations or subjective symptoms has got to be backed up medically in your records. And let me just add a little something to it, because I've had like 3 calls this week like this. You got to be compliant. Now, if the doctor's got you on opioids or antidepressants or something you don't want to take or don't like to take because it dumbs you down, the heavy mood stabilizers and so on, the problem is if you're non-compliant, Social Security uses that against you when they're determining your disability. And they also will use it at a continuing disability review if you're already on benefits. I mean, let's face it, folks, what is treatment today? Here, Robert, take some of these. Oh, those aren't working? Then take some of these. Oh, your stomach's upset? Then take some of these. Oh, you got nausea? Take some of these. And pretty soon, of course, you're on 15 or 20 different medications. But that is treatment today. And people are living longer. I mean, they don't lay on the couch and ask you when you first started hating your mother like they did when I was a kid. Today, it's take some of these. And one has to be compliant. They have to be seeking treatment. And no drugs. They treat, in my opinion, this is my opinion now, I sometimes believe that Social Security treats marijuana worse than they do heroin. because it was sold to the public as, hey, it doesn't hurt anybody, it's got a little medicinal thing, whatever. If you've got marijuana in your record, today, of course, especially under the Obama administration, what they've been doing with the pot dispensaries and so on, you are a federal criminal when you walk in that hearing room with the judge. Now, they don't call the cops, but what they do is they use it to discredit all of your testimony. You're just a person who wants to do, I don't care if you got a marijuana card or not, makes no difference. It's against federal law. And so what they do is they use it to discredit your testimony and conclude that you're just a pothead who wants to get more marijuana with the government's money. See, because they don't see this as your money that you pay taxes in. They see this as their money. Now, on the SSI side, that's really true because you did nothing to earn SSI benefits. That's pure out welfare for people who have not worked enough. Either they were younger, or they had other problems during their lifetime. So we've got that. Now, let's talk about the 5 steps that Social Security uses to determine one's disability, because it's very irrational. First of all, let me tell you, Social Security law says your doctor is not trained to say you are disabled. And he is not trained to say you cannot work because he has had no vocational training in most cases. Only the commissioner can say you cannot work. And of course, he's a lawyer, not a doctor. So everything that you've learned about how disability is determined, you can pitch out the window. For example, state disability. Those of you who were on state disability at one time or another, you know that your doctor signs the form and boom, you start getting money because your doctor says you can't work, you're disabled. Social Security says, no, he isn't trained to say that. Only the commissioner is, and he's a lawyer. This is your government at work for you. So, step number 1, acronym, SGA, substantial gainful activity. Has the person made $1,040 a month gross since they said they could not work? If they have, and it's been for, anywhere from probably a 3 to 6 month period or longer, they are not disabled. I don't care if they got tubes coming out their nose. If they have made money, earned income now, not unearned. So we're not counting the rent and the dividends and the interest. We're talking about earned income from a job. Then they are not disabled if they're making $1,040 a month gross before taxes are taken out. However, if you haven't been working since you had your injury or whatever, then we go to step 2. Does the person have an impairment that is considered severe, not by you and me or not by your doctor, but by the Code of Federal Regulations? Starting to get my drift? Acronym alert, CFR, Code of Federal Regulations. That's where the Social Security Act is laid out and other regulations affecting disability and retirement and everything else. So, here's how Social Security determines whether or not you have a severe impairment. First of all, is it medically determinable? And second, would that impairment, the symptoms, the limitations from it, reasonably lead to interference that is more than just slight in at least one of the basic work activities? How do you like that? So, let's just take a, for instance, guy injures his back, he's a construction worker. Can't be on his feet. Too much, you got pain, the doctor says, hey man, you gotta sit, don't go back to work and all of that. Okay? Well, presumably you got your medically determinable impairment because the MRI shows that he's got a herniated disc and a fractured spine and whatever else, okay? Then it's got to be expected, remember, to last at least 12 months. So the doctor said, look, pal, you're not going back to work, you're done, okay? And it has to lead to interference that is more than slight in one basic work activity. Well, one basic work activity for most folks is bending, stooping, standing, sitting, bending, stooping, carrying, lifting, and so on. And if the doctor says you are not to lift anything more than 2 pounds, well, even the lightest job in the world gives you the opportunity to lift up to 10. Than 10 pounds in that job. So it has to be medically determinable, and it has to be lead to interference in at least one basic work activity. Step 3, does that person meet or equal a listed impairment in the Code of Federal Regulations? Now, we're already step 3. We haven't talked much about the doctors, have we? This is the government. Step 3, there are something like over 100 listed impairments in the Code of Federal Regulations. Everything from cancer to AIDS to vision to hearing to musculoskeletal and cancer and everything else in between, neurological, all that stuff. Most people cannot meet the requirements of a listed impairment. For example, affective disorders like depression. It has certain criteria that has to be met to meet or equal that enlisting. And probably 80%, I was talking to a psychologist recently, and we were talking because he knows Social Security rules very well, and we agreed that probably 80% of the people who are approved for Social Security and SSI, at least psychologically for sure, and probably physically as well, cannot meet a listing. 80% of the ones who are approved can't meet a listing. You have got to be really severe. And again, severity is determined by the independent medical evidence, not by a doctor saying you are severe or your testimony that you are severe. It's determined by the commissioner. However, the first 4 steps, and we're about to touch on number 4, but the first 4 steps, the burden is on the claimant to prove that they meet or they have severe impairment, they haven't worked, they have severe impairment, they meet or equal listed impairment. And then number 4, can the individual perform their past relevant work as it is performed in the national economy? I'll give you a great example. I had a hearing 2 years ago. I was just helping the guy because he'd been in city government in San Jose, and his best friend's one of the council members. And he leaned on me. I know him well. And he said, look, you got to help this guy. And I said, look, I don't do stuff out of state, but no. Okay. So the problem was this fellow's job by profession was that of no one would know him, I don't think. So graphics designer, okay? Now, when he was self-employed. So when he performed that job, he was lugging 60-pound stuff around to the place of business and all of that. So the argument would be normally, look, this guy's past relevant work was medium to heavy. Okay, give you an example. Sedentary, I mentioned. You sit 6 out of 8 hours, you lift no more than 10 pounds. The next heavier one up is light work. That's where you're on your feet 6 out of 8, and you lift 10 pounds frequently and 20 pounds occasionally. That would be a clerk at Macy's or retail, ticket taker at the movie, parking lot attendant, waiter, waitress. That's generally defined as a light job in the Department of Labor's Dictionary of Occupational Titles. The next, that's on your feet 6 out of 8, and you lift 20 pounds, 25 pounds frequently, 50 pounds occasionally. And then heavy, of course, the guy lumping out in the warehouse, that's going to be 50 pounds occasionally or frequently and 100 pounds or more occasionally. Well, this fellow was lumping this stuff around to the places of business of his clients. So we tried to argue that his past relevant work was medium because of the lifting involved. Well, the vocational expert that the judge called to testify at the hearing, this was in Arkansas, this vocational, she I should say, testified that this job is performed at the sedentary level in the Dictionary of Occupational Titles, and she's absolutely right, by the way. It is a sit-down job in most cases. If you work for Apple or somebody, probably, you sit there and, and do your thing on the computer. But in his case, the way he performed it was much heavier, but the judge would not accept that. She accepted him as sedentary. He was currently sedentary, but he was in his late 50s. So all I really had to do was prove that his job was heavier than sedentary, and we would have won that hearing. That's the only loss I had in 2011, was that thing. And I felt bad for the guy, and I even ate the expenses to try to help him out. So does the person retain the capacity to perform their past relevant work as it is performed in the national or regional economies. Then if they cannot, then we move on to step 5. Does the person retain the capacity to perform other work available in significant numbers in the national or local economies? Now, the burden on step 5 shifts to the commissioner. You don't have to say, look, I can't do that job because there's, no, the commissioner says you can do that job because there's 20 million jobs. Employability is never an issue. I don't care if you're, think you're too old, nobody will hire you, they don't like you, you got a bad personality or whatever, they won't hire you. Or all the jobs are in Buffalo, New York, and you'd have to uproot the whole family. None of that is considered at all. It's whether or not you physically and mentally retain the capacity to perform that job. To give you an example, anyone under the age of 50 is expected to make any vocational adjustment necessary to perform other work. Now, there are 137 unskilled, sedentary, sit-down jobs in the Department of Labor's dictionary. To give you an example, one of those jobs is nut sorter. And that's not at the Barbara Aaron's Pavilion either, Robert. That's the psych ward for those of you who haven't been there. Anyway, it is a person who sits in the field at a conveyor belt with a bunch of old ladies and sorts hazelnuts from walnuts. Now, in fairness to Social Security, they don't quote that job anymore because it's become too mechanized. There are not enough jobs available in significant numbers. However, they got 136 more just like it if you don't like that one. Dumb, unskilled, sit-down jobs. You don't have to know a thing the day you walk on the premises. Now, under 50, I got to prove that you can't be a nut sorter or an equivalent job. Over 50, it does change. It changes to the extent that they don't require you to make the vocational adjustment that they require someone under the age of 50 to make. And I don't have a lot of time to go into all of that tonight, but let me just tell you that it changes significantly at 50. So when someone calls me, one of the first questions I ask them is, how old are you? If they say 50, the antennae pops up on the top of my head and they have my attention. Or if they say 55 or 60, that's even better. Now, here's the process most of you know. I assume many of you are on benefits, so I'm not going to spend a lot of time on this, but let me just tell you. And what our office does, if you have us help you at the initial level, is we actually file for you. We have to get information from you, and so it's a little bit of a misunderstanding sometimes when I say we'll file for you, because I don't know your address, or your doctor visits and things like that. So we have to get the information from you. It is very tedious. The first disability report is something like 12 or 15 pages in length of detailed information. And then the ones after that, after they deny you, then those are a little bit shorter. That's the appeals disability report. The application itself is pretty simple. Who are you? Where were you born? You ever worked for the railroad? Who you married to? That kind of stuff. But the disability report is the one that is much more detailed. So you go through that. Then if you are denied, well, let me just say this. It goes up to a state agency. No one at Social Security makes, well, I'll say no. Application level and the disability in general. No one at the Social Security office makes a decision. They're there to collect information and to get it processed. That's all they do. So they then send your file electronically up to the State of California Department of Social Services. And in every state, Social Security contracts with a state agency to do the determinations. It is referred to, acronym alert, DDS, Disability Determination Services, within the Department of Social Services for the State of California. Now, in some states, I have a colleague that worked for them for a number of years in Missouri, and they were under, I believe, the probate department. Probation department. Okay? So it depends, but Social Security does that in all 50 states. They contract with a state agency to do the determinations because they found it cheaper to contract it out than to have their own units. So you have a state agency person making the decision at the first two levels. And then the appeals go this way. If you are denied, you have 60 days to appeal that decision. And you file what's called a request for reconsideration. Social Security, would you reconsider my claim? I'm really disabled. I can't work. I don't care what the state agency guy said. I can't work. Please reconsider. Then if they turn you down at reconsideration, by the way, it goes back up to the same state agency. And the medical consultant who looked at it before hands it off. I mean, they don't really do this, but I envision this. Hands it over to his buddy across the aisle and says, hey, will you turn this guy down? They don't do that. So let me make it clear. I'm just jesting. But the fact is, it goes to another medical consultant, another analyst, different from the ones who made the first decision. Okay? And they look at it again, and they legitimately look at it most of the time. Then if they issue another denial, then you request an appeal or file a appeal to request a hearing before an administrative law judge. Now, let me give you the time frame. Right now, DDS is taking about 3 months before they even pick the file up. They're that far behind. So you're looking at 6 to 7 months minimum for a decision at the first level now in most of the DDSs. At reconsideration, that goes usually a little quicker because they don't have to get any more evidence on you. They just look at it again. And that's going to be about 4 to 5 months as a general rule. And of course, if you had a month in between while you were fooling around appealing it, you're now in the thing, 10, 11 months, something like that. Then when you are denied then, you waste another month filing the appeal, so that's 12 months. And the downtown hearing office for San Jose area is running about 10 months to a hearing, which is very good, by the way. There have been times when some of the offices in the past were running 2, 3, 5 years, in fact, I think was Kansas City at one time. So to a hearing after you've gone through the first process, to processes. So anyway, so things are moving along real quick now, except for the state agency, which is about 2 or 3 months behind in even looking at it. Now, my office, what we do is we call the state agency after about a month after we file to make sure that the local office send it up to them electronically, find out if they need anything that we can help them get, because we're very proactive with the folks that we represent, and we try to help speed it up. So here's your process. Initial app, reconsideration. Request for a hearing. If you lose there, it goes to the appeals council. I mean, if you appeal. Now, there are no appearances necessary. That's in Falls Church, Virginia. It's what we call judgment on the pleadings. So usually if I'm representing someone at the appeals council level, I'll file a brief, and they will allow you to file or submit new and material evidence. Then if you lose there, you can file a suit against the United States of America, the Department of Social Security Administration in the United States District Court. And well, let me give you an example. At the initial application nationwide last year, just got the numbers in last week, they approved 34% of the people who applied, 1/3. Half of those go away. The ones who did request reconsideration in California, 10.7% were approved. Half of those go away. At the hearing level, 2 years ago, we were 58% approval by the judges. Last year, it was already down to 50. You've been reading in the paper about all these people that are not really disabled. They're a bunch of con artists trying to get the government's money. Well, because of the pressure they're putting on the judges now, threatening to fire them, the Office of Personnel Management for the federal government, they are now down last year to 50, and we're expecting them to be down around 40% approval rate this year. They're turning anybody down that gives them an opportunity because they've got so much pressure on them to turn people down now. It's terrible, truthfully. I wrote an article last fall, late last fall, that was published last fall, I guess, or January, in a national professional trade magazine. And I entitled the article, "Let's Flog the Disabled," and the judges and their representatives too. Because that's what's going on. Ever since you saw that untruth that the Wall Street Journal began publishing in May of 11, and it's all been, even the commissioner testified last June before the Senate Finance Committee, and he even said it was most of it was just plain untrue, and most of it, or he said at best, some of it was half truths and the rest of it was completely untrue. And then just last week or week before, the 8 previous Social Security commissioners signed an open letter saying that National Public Radio report from a weekend a couple of weeks ago, how terrible and phony and false it was. And it was horrible of how they pictured it. It's called Unfit for Work, if you didn't hear about it. And it was terrible. It just nothing but solid lies. And NPR stood by it. And 8 commissioners signed an open letter to the public telling them how false that program was in the way it pictured the disabled. It's horrible what's going on with, with poor disabled people, folks that have had, some tough times out there. After the U.S. District Court, and by the way, the approval rate there has gone from about 50% down to 40%. And the Ninth Circuit Court of Appeals, you better have a good, solid reason to go up to the Ninth Circuit. And, of course, the United States Supreme Court, which most of us in this room couldn't put all our money together and be able to afford a lawyer to take that one up, even if it had some merit. Now, let me just talk about brain injury. Do we have brain injured folks here tonight? If not, I'll pass on this particular slide. Any of you suffering from any kind of brain injury, accident, that kind of stuff? Okay. Well, I have this because I do work a lot with this. No, don't mention any names now. No matter who you think. Okay. No negative comments. Now, I have this slide in here because I do a lot of programs for brain injury. Okay. Let me just touch on a couple of things here that are appropriate, though, for people with disabilities as well, or psychological, depression, schizophrenia, things like that. That is, we always, not only do we have to have good medical records, but we always try to get a residual functional capacity form from the psychiatrist, psychologist, or treating physician or neurologist, whatever is appropriate. Because Social Security, I didn't mention this to you, at the DBS level, they send you to these doctors who, by the way, are paid $67.50 for a comprehensive exam and to dictate the report. The prominent one is Health Analysis down on Santa Clara Street, and then they also use a couple of others. These are national contractors, and what they do is Social Security pays them $133, and they split it with the doctor. The doctors are generally completely retired, or frequently they've been fired from different jobs, and they can't get a job. So they're doing these exams. I had 2 medical consultants. This was not here at Health Analysis or, the local physicians, but this was medical consultants in Oakland, the state agency up in Oakland. And I had 2 cases, 2 doctors, and then they were so egregious in the write-up about my client, this was a number of years ago, that I just, for the heck of it, decided to check them out on the California Medical Board. Well, I found one of them was on 10-year probation on his medical license for Medicare fraud. Pleaded guilty in Superior Court. The second one was on 10 years probation on his medical license because he killed a guy at San Quentin. Now, he did not strangle him, for those of you who'd like to juice up the story. What he did, it was his negligence. He looked at the guy, didn't do any of his vitals. The guy had fallen out of a second-story window. And then on top of that, he called the wrong hospital, got the wrong ambulance, and the guy died on the way to the hospital, which was the long ways away. And so the Department of Corrections fired him. He went across to Oakland and was hired as a medical consultant. So understand, whenever you are working with a government program, that's the kind of stuff that you need to be prepared to deal with. Okay? So we need a medical source statement from your doctor if you're applying, and I'll tell you why. Because their doctor's going to say you can run the Boston Marathon, your next Albert Einstein. They're paid, in my opinion, I think they're paid to do that. Okay? So, if we don't have your doctor on board, when you get in front of a judge at the disability hearing, he is absolutely obligated to take their doctor's word because in the Code of Federal Regulations, CFR, he is an expert. One of the doctors, I was looking at reading a report last night, who's a prominent one here in San Jose that does most of the physical reports. He graduated from high school in 1949. And he probably does it. You know, I don't mean he's a bad doctor. I will tell you this, though. He sure gives everybody at least light and frequently medium. I had a lady, it wasn't him, it was a different one, doctor down there. I had a lady a few years back where she was on a 4-point walker, prescribed, had spinal bifida, all slumped over, lots of psych problems with self-mutilating herself. You know, I didn't go together well, but anyway, self-mutilating and all kinds of problems. And not this doctor, but a different one, this doctor that could lift 25 pounds frequently and 50 pounds occasionally on the 4-point walker. And that's routine, by the way, for them to say stuff like that. So it was really interesting. I was at a meeting down at the courthouse, unrelated to the hearing office, across the other side there where the U.S. District Court is. And one of the judges that had this case assigned saw me standing in line to get through the metal detector. And he walked over and he kind of looked around because they're not supposed to talk about cases ex parte, you know, off the record. And so he looked at me and he says, you know, everybody knows that doctor gives every client that goes in there light on their feet, 6 out of 8, lifting 10 and 20 pounds. He says, she gave your gal medium. He says, you must be representing Superwoman. And he chuckles and walks off, canceled the hearing and paid the case. They know. But they're obligated to take those phony reports if you don't produce one that trumps it. Now, there's something in Social Security rules, not only the CFR, but also the SSR, acronym alert, Social Security rules, Social Security ruling 96-P from 1996, called the treating physician rule. And that says that if you have a statement from the treating physician and you've been seeing that treating physician where there's a treating relationship, and I usually tell people, look, I don't want to talk to them unless you've been seeing a minimum of 1 year. So there's a treating relationship with this guy, and this guy makes a statement that, you know, you're limited, you can't sit, stand more than a half hour, you know, those kinds of things. Then Social Security is to take his word, provided he is backed up by the medical record as a whole. So, for example, my doctor cannot say in a statement, Mel doesn't know his own name, unless there is a reason in the medical record why Mel doesn't know his own name. For example, traumatic brain injury. For example, early onset of dementia. For example, Alzheimer's. You know, in other words, there's got to be something medically determinable why Mel doesn't know his own name. So no matter what your doctor says, he cannot just be advocative in nature. He has got to be backed up by the medical record as a whole. So if some other physician looked at it, or psychologist, he would come to a similar conclusion. While we're on that subject, let me briefly mention the chain of command, or the feeding chain, for acceptable medical sources with Social Security. The only acceptable medical sources are MDs, whether it's psychiatrist or internist or whatever, MD, DO, which is an osteopath, which they prescribe and so on, okay, and a licensed clinical psychologist. Anybody below that, like your friendly nurse practitioner, physician's associate, they would be on the next level. So they are trumped by Social Security's doctors because they're not an acceptable medical source. And chiropractors, just to give you a rundown, some people do get some relief from chiropractors. Chiropractors are at the very bottom. They are listed, I'm not kidding you, they are on the same level as acupuncturists and the massage parlor around the corner from your office. They call the chiropractors in the code massage technicians, because they can't prescribe and they will not accept them as an acceptable medical source. Now, they have issued a ruling that said that you can take x-rays from a chiropractor, but I saw a fellow that was turned down. I wasn't the representative record, and the judge disallowed that, did not accept it because the x-rays were taken by a chiropractor. And that's really adverse to Social Security's position on the x-rays. But they certainly could not take the chiropractor's word like a radiologist about what the x-rays say. They won't take that because he's a massage technician. Okay? Now remember, Social Security is determined by functioning level, not how bad you've got it. Let me just talk on this a little bit. If you are on special SSI, or you have a child or other family member on SSI benefits, remember that is federal Medicaid. It's welfare, right? If my daughter is on SSI and I leave her my house, what happens to her SSI and her Medi-Cal? Poof, gone. Because remember, you have got to get it. And the minute somebody leaves you money or a house or anything, and your total assets, total reachable assets, hit $2,000 or above, you lose it. Yes, sir. You have a question? Well, yes. Let me explain that, because you're absolutely correct, but it's also a little bit misleading. So let me explain. If you read that brochure that I brought from, okay, I will do that. Okay, the question was, are you allowed to own a house and other assets when you're on SSI? And the answer is yes, but you can't receive it as an inheritance. So, for example, if you look at the brochure that I brought today about what everybody should know about SSI, you'll find that when you apply for SSI, you can have a house, furniture, one car, burial plot, a little bit of cash value life insurance, a couple of nickel and dime things beyond that. Other than that, it's got to be a welfare case. And if you have reachable resources of $2,000, or if you're married, a total of $3,000 between you and the spouse, then you do not qualify. $2,000, you're wealthy for this program. Okay? Now, to answer the question more specifically, let me say this. If you are able to buy a house, but that's almost impossible on SSI for a couple of reasons. One is you can only have $2,000 amassed, or you lose your benefits. So how are you going to save up for down payment? Secondly, being on SSI at $854 a month, how is one going to afford a house? However, if someone does leave you a house or money or other assets that are worth in excess of $2,000, you will lose your SSI and your Medi-Cal. Simple as that. And you also have an absolute affirmative duty to report it, or it's fraud. You know, and those of you on SSI, when you looked at your award letter for the first time, you'll see it's like 15 or 20 pages, and the last 9 pages is like all the what you got to notify us about. Okay, if you move, if you change, you have any income, and so on. And so you absolutely, if you get an inheritance, you have got to notify them. So what you do is you have mom and dad, or if you're the mom and dad for the disabled child, you set up a special needs trust. You can do it within your revocable trust. That's usually the least expensive way to set it up. Or if you wanted as a grandparent, let's say, to set it up for a disabled grandchild, you can do a third-party one where you can contribute money using the gift tax exclusion to that trust every year for the benefit of the child. The real key to a special needs, without going through all this stuff, is that the child can never compel a distribution. The child cannot sue the trustee and make that trustee give that child money. However, it is there and very clearly spells out that it is used to supplement anything that SSI or Medi-Cal allows. For example, sending his brother with him to Disneyland, fully acceptable. But you got to pay it. You can't hand the child the money. Okay? So there are certain things, as long as you're not providing food and shelter, and it is used to only supplement. For example, person's in the hospital, and there's 4 people screaming all night long in the ward, and he can't sleep. You can buy him a private room because Medi-Cal's not paying for it. and you can use it to buy that extra room, or, you know, private room. So there's some things that you can do, but I would really encourage you to look into that if you have anybody in your family that is special needs or handicapped and that kind of thing on benefits. I'm not going to go into all of that. If you'd like information, just always call me. Anyway, Robert, pretty well does it. We have about 4 minutes, I guess. Is that by your time, or? I'm just going to off questions answered briefly. Anyone have any questions quickly? Yes, sir, in the back. Oh, okay. Let me answer the question quickly, because I can do this quickly. The question was, is the public looking at disabled people differently? It's not the public, it's the politicians and the news media. For example, last April, a year ago, Sam Johnson, who I've always respected, he is the chairman of the Social Security Subcommittee for the House of Representatives, Congress. He said that most people who are applying for disability, and this is a quote, are nothing more than con artists. And there was a half-truth written, the whole thing started front page Wall Street Journal, May of 2011, if you want to go back and look it up. I don't remember what day. And this reporter took a judge in Appalachia who was using SSI as a welfare program, and he was approving 97% of the people who applied. I mean, it was a real aberration. And he applied that to everybody. Hey, you can't work, you know, unemployment's run out? No problem, come on down and get some money. And everything after that has been that way. But they haven't taken in the real consideration of why the applications have increased for disability. You've got people, the population's growing older because the meds are causing us all to live longer. You have many more women in the workplace than you had 30 years ago, or now, and particularly because they're doing what was formerly done by men in many cases. So their backs are going too, you know. And you also have situations where people just get to the point where they just can't work. I mean, they're in the trades. My perfect guy is a guy in his 50s that was a carpenter or electrician doing heavy work. That's my perfect client. You think about the 5-step sequential evaluation. I don't have to prove he can be a nut sorter, or that he can't sort nuts, I should say. What I have to prove is that he can sort nuts. That's the vocational adjustment when you hit 50. In other words, if he can do an unskilled, sedentary job like sorting nuts, and his past relevant work was heavy, we win. But again, the whole thing's got to be backed up by the record and all that. Okay? But anyway, you can find all over the internet. It's terrible. But even the commissioner has defended, Commissioner Astrew and now the other 7 behind him, have defended the program and said it's an absolute untruth. The way the politicians are doing it. One politician in Oklahoma, he went on a witch hunt with the local hearing office and tried to prove that these judges, so out of like 300,000 decisions, they found 3 they didn't like. I'm not kidding you. And then used that to try to gain votes. That was Tom Colburn, by the way. Well, that's what the allegations are. You know, unemployment ran out, so now let's go down and get some disability payments. Well, you know by the percentages, and those of you who had to fight them to get them, you know what I'm talking about. They weed you out in a hurry down there. In fact, the commissioner even testified to Congress a few months ago. I watched on C-SPAN that less than 40% of the people who originally apply are ever granted benefits.
Good question here, Mel.
Yes, go ahead.
What is your advice for an SSI receiving individual? How does IHSS get affected by a job? How much would I have to make to cover my SSI, IHS, and live comfortably? Or live on my own, sorry.
Okay. First of all, I assume we're talking about in-home support service?
Yeah.
Okay. In fact, that has really 2 ways to look at that. One is I have had situations where the person was unable to work. Only they found an easy way to get some cash, watching mom. And the county was paying them, you know, $10 an hour or whatever. And now my good case just evaporated because they were making over SGA, substantial gainful activity, $1,000 a month, and they just negated their whole case by doing that and not telling me. Okay, that's how it affects that way. Now let's go back the other way. If a person is working and they are making above the limit, now for SSI payments, of course, that's going to be roughly $854 a month. Now, remember, they let you keep one for every two, and, so it plays out. You get a little bit more. But the fact of the matter is, if you go to work and you're on SSI, generally you're going to have, not generally, you're going to have reductions. And I don't know, Robert, to answer the question specifically about in-home support service from that perspective, how that would affect it. But certainly if you've got a job where you're making probably a fair amount of money, you know how hard it is to get Medi-Cal. It's basically the same idea, the same rules. Yeah, I'm not sure of the number, but did you hear that question? She was suggesting that to get Medi-Cal, you can't be making more than about $900 a month. And I don't know if that's the correct number or not, but I will say this, they're going to have a limit. And so to answer the web person's question, clearly you have an affirmative duty to report any income if you do go to work. And nobody's going to discourage you from working, but they may take away some of your benefits if you are, depending on how much you're making. So you really need to lay that out on the table before you make that major step to go to work.
We'll go to a question now.
Okay, anyone else have a question here in the live audience?
Here's a question here. It says, if I trigger the 9-month work period and I'm unsuccessful keeping the job, does a new 9-month period begin if I find another job?
No. Here's the way it works. As I mentioned earlier, it's a 5-year rolling 9 months. So let's take April of 2013. So from April of 08 to December of 08, you work 1 month. In 2009, you work 2 more months. That's 3. In 2010, you work 3 more months. That's 6. In 2013, you work 4 months. That's your 9 months, and you're off benefits. Well, not necessarily off, but any month after that you make $1,040 a month gross, you will lose your check and your benefits. Does that answer the question for the person? It's 9 months, but it's not consecutively 9 months. It's a rolling 5-year period.
After those 5 years,
well, what happens if you go into 2014 in my example? The one in 2008 dropped. See, it's a rolling 5 years. Right. And in 2009 to 2015, 2009 would drop. See, that's how you get the 9 months going again. Uh-huh. Right, your trial work period, uh-huh. You used up your 9 for a 5-year period, if you think about it. Yeah. But, Social Security has a brochure. We have some at the office. I probably should have brought them back, but I wasn't sure who the audience would be. And that is Working While Disabled. And it's available on their website. It goes into all of that. Yeah.
Here's another question, too. It says, can I keep my burial plot without being penalized my SSI? Would I get penalized?
Well, you plan on using it? Oh, no, I'm kidding. I'm teasing with you, of course. Burial plots allowed. I think they have a value, though, of $1,500. Anybody know right offhand without me looking in the brochure here? There is a limit on the value of it, but normally a burial plot is not an issue with most folks, and frankly, because they don't own one. But even if it is, they generally don't have money to go buy one, and if they do, it's usually a family plot that they came in with. And just quickly sort of looking here, Okay, items that do not count should be right here. Settlement, bills paid, those types, money in account. I don't see it right offhand, but yeah, go ahead.
Since voucher aid is not open now, what is a country that is more given to people with disabilities or state?
What country?
Or state in the U.S. Maybe the
well, other than being,
maybe county. Yeah.
oh, maybe. Oh, thank you very much for the clarification. I was going to say, well, let's see. Let's go to Zimbabwe. We'll start there, and of course, you'll miss dinner. Yeah. What county? Well, remember, the SSI is federal. Social Security is federal. But let me just give you an example, because I do have done some work and some seminars and things up in Oregon. So let me give you an example of the SSI program there and the SSI program in California. In California, California provides you with a supplement, a cash supplement. That's why you get $8.54 a month, okay? Part of that's a supplement from the state of California. Now, and that is to replace food stamps, because with SSI in California, you do not get food stamps. You get cut off of them, but you get cash instead. In Oregon, you get the regular basic federal Medicaid payment, which is about $700 a month, $710, something like that, and food stamps. They don't give you a cash settlement. Here you get like $8.55 and no food stamps. There you get like $7.10, which is the federal rate, and food stamps. So it will vary that way as to how it's administered in each state. But as far as the program, it's a federal program. And same with Social Security Disability. It's a federal program. And for that matter, food stamps is a federal program. So those are not going to vary from state to state, but they're going to vary as to how the state administers them. Okay? So that's that. Now, and same with the county, by the way. From county to county, it really makes no difference in California, because the whole state administers Medi-Cal, a certain way, and so on. I've really enjoyed being here tonight and appreciate your attendance. I hope you got a little something out of it. And I also have a stack of business cards. If you want to call me anytime, please do so. I will always be responsive to you and try to point you in the right direction. Okay? Thank you very much, Robert, for having me.
Everyone said it was great. Thank you, guys.
Oh, well, thank you very much, if you can hear me.